Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you.
Start. This application under section 561A Criminal Procedure Code for restoration of criminal revision number 198, which stood dismissed by default by virtue of this court's order, arises in the following circumstances: para. The petitioners filed a criminal revision application in this court challenging their convictions and the sentences passed upon them without a copy of the judgment of the trial court. Para. On the 10th February, 1 week's peremptory time was allowed for filing a certified copy of the trial court's judgment, failing which the revision application was to stand dismissed without any further reference to a bench. The trial court's judgment not having been filed within the peremptory time allowed by this court, the criminal revision application filed by the petitioners stood dismissed by default on 17/2/1956 by virtue of the above. Para. 4 days after the expiry of the peremptory date for filing the trial court's judgment, the petitioners filed the present application for restoration of the criminal revision and for condoning the delay in filing the trial court's judgment, which was filed along with this application, and for accepting it. The matter came up before us when we admitted the application, issued a rule in the case, and directed it to be registered separately as a criminal miscellaneous case. The rule has now come for hearing and final disposal before us. Para. In support of the rule, he has contended that as the criminal revision application was dismissed for default, this court has got the power to restore the case, because such an order of dismissal for default is not a judgment to which section 369 Criminal Procedure Code is attracted. In support of his contention, he has relied on a number of authorities of different high courts, including some unreported decisions of this court. Para. The ratio decidendi of these cases is that section 369 of the code is no bar to the restoration of a criminal revision application dismissed for default, because such an order of dismissal for default is not a judgment within the meaning of section 369 of the code. He has also referred us to the recent decision of the Supreme Court. Para. The learned standing counsel appearing for the state has, however, placed reliance on supra, in which a contrary view has been taken. He has also placed before us, in which it has been held that the High Court, in the exercise of its powers under section 561A Criminal Procedure Code to secure the ends of justice, can restore a criminal revision which was dismissed for default without going into its merits. Para. The question for our determination, therefore, is whether this court has the power to restore a criminal revision application which has been dismissed for default. Stop. Para. There is no statutory provision for such a restoration. Stop. The power to restore a case dismissed for default, if it exists, must therefore be an inherent power which is saved by the provisions of Section 561A Criminal Procedure Code. Stop. This section was inserted in the Criminal Procedure Code by the Amendment Act of 1923. Stop. It is merely a saving clause which does not confer a new power on the High Court. Stop. The decisions of the High Courts prior to this amendment are therefore still applicable. Stop. Para. A long line of decisions has established that, as provided by Section 369 Criminal Procedure Code, the moment a judgment is pronounced and signed, the High Court is functus officio, and neither the court itself nor any bench of it has any power to revise that decision or interfere with it in any way. Stop. Even under Section 439 Criminal Procedure Code, the High Court has not any power to review its judgment pronounced or revision in a criminal case. Stop.